So we got that.
So this is where we should all do the pledge at the same time.
Do we need the scout again?
I get, what's that? I guess we can, or we
Do
could
we
just.
need the scout again?
Yeah, if you guys want to do it. If that's what we're gonna do, let's get going. Do we got somebody?
I think Holly was
Or
gonna
no?
get her boy.
Okay, I got it.
Who?
Everybody see the flag going right now?
He's refusing. He doesn't want to do it this time.
All right.
Then we'll
That's all
all
right,
do
we'll-
it.
Well, we could skip a week.
What?
Okay, Dan, go ahead. Start us off.
I pledge allegiance to the
to the
flag
flag
of the United States of America and to the republic
for which
for
it
which it
stands,
stands, one
One
nation,
nation,
under
under
God,
God,
Indivisible
indivisible,
Liberty.
Liberty
indivisible,
for all.
justice for all.
for all.
I think what's funny is Dan stopped talking because he wanted to make sure everybody else was talking. I think he was taking notes on who wasn't actually reciting it.
That is not true. I was waiting for the lag to pick up, but then I realized we're working with a bunch of retards here.
Oh, stop. We're recording.
Daniel Thomas.
All right, here we go. So, last week we ended the Fourth Amendment. We're going to get into the Fifth Amendment today. And I think we're probably going to get through it. I said it was going to take a couple weeks, but I think I'm going to stick with my new thought process on this, and we're just going to hit it in a real general sense and get through
Bill,
it.
stop sharing.
Stop sharing. Got it.
All right, we good,
Sorry
Bill?
about that. Got it.
All right, I can't say anything because I'm on Prezi, so, yeah, so I think we're just gonna get through the Fifth Amendment today in a general sense. Now, there is a whole lot, and I'll talk about where these different, the different sections of this that have a lot, and if you want, you can just go look this stuff up. If, like always, later on, if I start getting emails from you guys or messages and you guys want to talk more about it, then we could just devote an entire, another entire week to it. But, so moving on here, let's see, what time is it? 8:05. We should be good. We should be good. So Fifth Amendment. So the Fifth Amendment, what it says is that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So did you guys all get that?
Yep, class over.
Yeah, class over. That's a lot.
All done.
Yeah, that is a lot right there. But like always, we'll break it down. We'll start with the 5 protections in this thing, because as we're reading it, you kind of glaze over and we get about halfway through with that. So basically what the 5 protections are here are an indictment by grand jury, double jeopardy, self-incrimination, due process, and eminent domain. Eminent domain was kind of weird to me. I didn't read deep enough into it to see why eminent domain was there when everything else was kind of protecting you during criminal proceedings, and then they threw eminent domain in. Now, I know eminent domain was not a big deal, and I think it was Madison that threw it in kind of in the last minute. There was already, all the way back from the Magna Carta, there were already protections for your private property from the government. So I don't know if this was just one of those things where he just threw it in wherever it fits. But we'll get to all of them. Anybody have anything right now? Any questions, any comments, anything at all? I got David Davis back here, so hopefully he's going to be able to chime in a little bit. All right.
I got nothing yet.
All right. So moving on. So we'll start with the grand jury. And what the grand jury says is that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. So first off, infamous crime is typically and always has been just a felony. Now, when we're talking about the grand jury, it's important to remember that this is one of the few parts of the Bill of Rights that the Supreme Court has never included in the 14th Amendment. So the grand jury here only refers to federal cases. You have no federal constitutional protections when it comes to state cases. Now, Ohio is still a state that uses the grand jury. Some states don't. Some states take it all to the prelim. Now, since we use a grand jury, I can't tell you the last time I actually testified in a preliminary hearing. That's one of those things that it is part of the of due process. It's part of the legal process. So we always get subpoenas for it, but almost everybody waives it. And that's basically just establishing whether there's probable cause to even be there. Cases of felonies, and that's the only time that a grand jury will convene is in a felony, a capital crime, or otherwise infamous crime, which is felony. That will come later on down the road, which is why everybody waives it anyway. Because if it doesn't get through the grand jury, then everything else is kind of moot. Some states don't have it though. Some states do not have a grand jury. You would have to check with each of your states. Now, it is protected in Ohio under it is under the Ohio Revised Code. To be honest, and I should know, and I don't, if it is part of our Constitution. Does anybody know?
I do not, but that's an interesting question.
I have
I
failed
don't
to
off the top of my head.
Yeah, I don't know. But it is in the Ohio Revised Code. So it is a protected part of our process. So the structure of a grand jury. So basically what a grand jury is it is a closed session. It's a secretive session. No judge, no defense, no accused, no press. Rules for evidence basically non-existent. So what happens is the prosecutor will present a case to the grand jury, which in Ohio I think is 9 folks. Federal grand juries can be up to 23. There are hearsay admissible, whereas hearsay is not admissible during a criminal trial. Hearsay is admissible in a grand jury environment. The defense and the accused don't have a right to hear what that evidence is that's being presented. They don't have a right to cross-examine. They don't have a right to cross-examine the prosecutor who's presenting this evidence. There's no judge there. It is just the prosecutor, just the grand jury. And when the prosecutor's done, he asks the grand jury to return a true bill, it's called. If the indictment is successful against the accused, it's called a true bill. It's a no bill if it is not. I will say that it is pretty difficult to get a no bill. There was a justice at some point who was complaining about the grand jury process, said you could indict a ham sandwich. And I believe that is true. It is not hard to get an indictment, but you understand why, right? I mean, it's closed, it's secretive. The jurors are never released. The evidence is never released. You don't know why you were indicted. And you almost never know why you were indicted. So now the indictment is not a conviction by any means. Basically what the indictment is doing is saying, yeah, we're going to continue on with this. No, we're not going to continue on with this. That's it. It's just a step. If there's a no bill, the case is over. Now they can charge you misdemeanor level in the municipal courts, but normally if there's a no bill, that's it. It's done. So, but like I said, it's tough. It's tough to get a no bill. It's not as tough now, I guess. I know the first 15 years I worked, I mean, I never heard of a no bill coming down ever. So with that said, the Fifth Amendment was supposed to be here, like with the rest of the Bill of Rights, to protect you, right? It was supposed to be a shield. However, it was originally designed to protect the accused, but now, based on what I've said here, I don't know. I'm not sure how much protection there really is here with this section. I mean, the grand jury's kind of become moot, I guess.
Yes, who decides when it goes to the grand jury? I mean, is there a certain amount of length of time they're allowed to investigate, and then they have to go to the grand jury? Or
Well, no, I mean, every crime has a statute of limitations, but no, when you're talking about the felony level, it's a long time. Once we bring the charges up, the charges will get sent to the prosecutor. If they are a felony, they always start in the municipal courts for the preliminary hearing. Once that's waived, it just goes right over to the grand jury. Then you just wait for the grand jury to convene and come down with either the true bill or the no bill.
I'm still kind of confused. Like, who sits on a grand jury?
It's just like any other jury. You'll get a notice
Okay.
and telling you that you need to appear.
Okay.
Now, that's for Ohio. I don't know how it works in every state. Some states don't have a grand jury, like I said. And I don't know which states do and which states don't. I only know that Ohio does. So, but yeah, you'll get a jury duty notice. You got to show up. And then you just sit there and you listen to just case after case after case. And you're not finding innocence or guilt. You're just saying true bill, true bill, true bill, no bill, true bill, no bill, no bill. And you're deciding what cases are going to go up at the felony level through the rest of the court process.
Hey,
So then
Jim,
it's really up to the prosecutor then to decide when they want to take it to the grand jury and present the case?
Yeah. So once we send it up, it's usually a pretty quick process, but the grand jury also has investigative powers. They can call for witnesses. They can, a grand jury subpoena, the grand jury can subpoena witnesses to come in and testify. They can have the prosecutors, the prosecution investigators, they can have them go out, drum up more witnesses. They can ask questions. They can, they've got some power that a normal jury doesn't have. But yeah, it usually happens pretty quick. I mean, the prosecutor doesn't sit on it because once we start the process, once we formally charge you, then we've got, and that's coming up, the clock's ticking, right? Speedy trial. You got a right to a speedy trial. So the prosecutor, once we charge you with a crime, then there's really, I mean, the prosecutor's not going to sit on it because if they don't waive that right to a speedy trial, he's going to lose the case. Now, there is another twist to this is there's what's called secret indictments, and that is where we don't charge you. We gather our case, we gather the evidence, we go straight to the prosecutor, and the prosecutor goes to the grand jury without you ever knowing. So by the time you get arrested, if they true bill you, you've already been indicted by the grand jury. So once a grand jury comes down, that's when the charges come down. And we'll do that for like drug investigations, things like that, things we don't want people necessarily to know about right off. We have a good case, but there's, other things at play where we just don't want to give people time to talk to people, escape, whatever the case may be.
Hey, Jim, as an officer, do you find out if your case was true billed or no billed?
Yeah. You don't usually find out the same day. But yeah, it's just like any other case. They'll let you know.
I had one, I had a traffic stop and the driver tried to run me over. Prosecutor, was it Dennis Will, wanted to charge him with felonious assault.
Mhm.
I went to the grand jury and I never heard anything after that. So I,
Yeah, well, you should,
figured
because
it
you're
was-
listed as a victim. The victim's advocate should be getting a hold of you, when stuff like that happens.
Right.
All the grand juries really do is just tell the prosecutor whether or not they have enough evidence to take it to trial.
In a perfect world, the way it really works is that the prosecutor asks them basically to go ahead and send this thing through, and they do. I mean, that's typically the way it works. And that's my biggest problem with it. That's always been my biggest problem with it, and I've always had problem. I've never quite understood how you could do something like this that affects somebody's life so immensely, and they don't have a right to be there. They don't have a right to cross-examine. They don't hear that. I mean, the evidence could be completely manufactured. There's nothing, the rules of evidence are out the window at a grand jury. So, I mean, you could be being indicted on nothing.
I just got off the grand jury in March. So.
For
if
Lorraine
we
County?
felt- Yes, if we
Yeah.
felt there wasn't enough evidence,
Oh,
then
sure.
we wouldn't true bill it.
Right. And that happens, but that if the prosecutor's bringing his case there and he thinks that he has a pretty good case, he tries to lean or steer the grand jury towards a true bill. I mean, it's just, I mean, it's his case. He wouldn't be bringing the case to you if he felt that he was going to lose the case. And they'll do that sometimes. Prosecutors will tell us, nah, we're not going to do this. You know, keep it down at the municipal level. So that's it. Anybody else, anything?
Oh, Jim, I'm glad you're taking the time to share this with us because this is the nuts and bolts at the tire meets the pavement level that we regular citizens never get to see or hear.
Well,
So
right.
this
And
is
by the time you do hear about this, now you get real interested in what your constitutional rights are, right?
Right.
Like you never care. You never care until the police knock on your
right.
door and walk in your living room. And now
Right.
you're like, hold on.
Yeah, this is the actual operational level at the human level of what these rights are.
Yeah, for sure. All right. So the exemption here, and there is an exemption that is in the Constitution. Now, you know, a lot of exceptions and exemptions and things I don't agree with because it's the court's ruling on what these exceptions are, right? And when the courts rule, and I understand it's their job to interpret what the Constitution means and what it says, but when they're interjecting their own exceptions to the Constitution, I have a problem with it. This is an exemption that is actually spelled out in the amendment itself. So it says, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. So Brad, you here? Is Brad here tonight?
Yeah, I'm
He's
here.
here. Yeah,
Okay.
he's here.
Yes. So, I mean, Brad, really. So the military, the active duty military is exempt from this, from the grand jury. They handle all their stuff through court martials.
Correct. They have the as part of the oath is the follow the Uniform Code of Military Justice.
Now, this has gone back and forth, and I don't know where it is right now about offenses that occur outside of military installations, outside of their duty. I know it had been that if it happened outside, it's the jurisdiction where it happened, but then it came back around 20 years ago, and it came back around that nope, they're still exempt because the Constitution says they are exempt. Now, where it says, and it's all punctuation, so it could be read either way, but it's always been, and the courts have always ruled that except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. The actual service in time of war or public danger applies only to the militia. So the way it should be read is except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. So the regular military, they've always got it, and the militias are only during actual service in time of war or public danger. So, you know, if the National Guard gets called up for these raids that were going on and commit a crime, something happens, then they forego the grand jury.
So, hey, Jim,
Yep.
if we're talking about in time of war, we haven't had a war declared since World War II.
Right.
Does that still apply if it's an active military operation?
Yeah, but we're
Not a
talking
war.
but we're talking about the militia. So, you know, and then we got to go back to what is the militia. You know, I don't know, Mike. That's a good question. I don't know. I would have to look to see. This is one of those things. I guess I would have to look to see what the current case law is on that, because I think everybody who was in Afghanistan over the last 20 years would probably disagree that they weren't in war. I understand that technically Congress never declared it a war. So I don't know. I mean, that's a valid question, I guess.
You've got presidential executive orders declaring places war zones for
Yeah, I was just
combat.
wondering if this is like, an active duty thing, like an active duty during a time of conflict or an actual war by definition.
Yeah. Yeah, I don't know. I don't know, because even when we talk about this stuff, I always, all right, whenever we're talking about war, you assume that the Middle East is a war.
Well, I mean, they do reference public danger, so that's pretty encompassing, don't you think?
Yeah, but
Would maybe cover that.
militia though, I've got a feeling that public danger is more, well, it could be because back then, well, no, even back then, I mean, back then they had riots. They had, things where the military had to squash things. I take it to mean that public danger would be things here domestically, where things are going bad and they have to mobilize the military.
Oh,
That's how I take it. But I'm no judge.
What about
I
under
would
state of
agree.
emergency? Because I thought, as far as I think we're constantly under a state of emergency. I don't think anything's ever been lifted going back to like 9/11, I think.
Well, so take Kent State for an example. Was that
Yeah,
like,
I would guess that was. Now, remember though, this isn't that they get out of the crime. This is just that there is no grand jury requirement,
there's no civil trial technically?
or not even civil. It's just no, even if it's a criminal trial, the Uniform Code of Military Justice handles it through a court martial.
Right.
They have sole jurisdiction over their members. So this isn't saying that anybody gets away with a crime. They just don't have to go through the grand jury. There is no grand jury requirement for the military. So don't get too hung up on this. Yeah, I mean, we could talk about this all night. All right. Anything else on grand jury?
No, good stuff,
Right.
Jim. Good stuff.
Sorry, I keep itching my nose. Here's something a little fun. Just let me
Probably
digress.
stop snorting coke.
Yeah, exactly. Let me
Way to
digress.
the evidence locker.
Let me digress.
Pro
for a
tip.
minute. So this cataract surgery they give you, I don't know if anybody's ever had it, but man, the amount of eye drops you got to use and the frequency is unbelievable. And what I never knew is that your eyes are actually connected to your sinuses. And when you are dropping all these eye drops in, I could feel it going down the back of my throat. And as soon as I sniff, I feel it come right back up into my nose. It's the weirdest thing. So that's your little anatomy tidbit for
Yikes.
the day. Yeah. I can taste them when I put them in my eye. It's the
Oh,
weirdest.
man.
Yeah, it's
You are the new Luke Lelouch breathing through your eyeballs.
but they're yeah, right. But I just took them a little bit ago, and as I sniff, now it's burning my nose. So anyway, all right. So second one is double jeopardy. Everybody knows pretty much what double jeopardy is. What it says is, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So in a nutshell, what it means is that it's there to prevent the government from trying the accused over and over again for the same crime, right? So the government charges you with a crime, you get found not guilty, you're acquitted of the crime. The government can't now say, nah, we think he did it. We're going to try again. And then they're going to come back and they're going to try again and try again and try again. So it's one and done. If they charge you for the crime and we get to where you're acquitted, then that's it. You're free to go. You can never be charged with that crime again. And it doesn't matter what evidence. I mean, the government better make their case the first time, right? So if it's a murder trial and they take you all the way through, you get found not guilty, you're acquitted, you're free to go. Then 2 weeks later, they find the body or a witness comes forward or whatever the case may be. Too bad. Right. Once you're acquitted, you're acquitted. That's it. It doesn't matter if more evidence comes out. You've been arrested, been tried for this crime. You cannot be tried for this crime again. Now, there's exceptions to it, just like everything else.
I always think the Ashley Judd movie.
I can't remember. There we go. So there's
I just watched that like 3 days ago.
Yeah, there's exceptions to double jeopardy. One of them that always comes up is if you or your attorney were to bribe the court, which doesn't happen often, but happens, where a judge is bribed.
Happens more often than we think.
Right. So they do not attach double jeopardy to that. If you can prove that this judge was bribed, the courts have ruled that there was never any jeopardy because
Right.
you were never going to be found guilty.
You are
So
in
there-
jeopardy, right?
Right. You were never in jeopardy. From the time this trial started, you had bought the judge off and the judge was going to find you not guilty. No jeopardy. So even though you're found not guilty there, they can come back and they can try you again, same crime. The one that causes a whole lot of confusion for people is dual sovereignty doctrine. And what the dual sovereignty doctrine is it gives the government the right to try an individual for what appears to be the same crime. So when we talk about this, think of Rodney King, Derek Chauvin. So Rodney King, these guys were acquitted and the government immediately swooped in and tried them for the exact same crime under federal civil rights. And they were going to do the same with Derek Chauvin. Had he been found not guilty, they would have come in and arrested him. And I guess the plan was to arrest him right there. So he didn't have a chance to get away. They were going to arrest him right there and they were going to try him federally for the same crime. And what the court says in this is that both have interests. The crime had occurred. It's both a federal crime and it's both a state crime. While it appears to be the same crime, it is actually two separate crimes. So even though Chauvin kills George Floyd, the state has a case against him for killing George Floyd, but there's also a federal civil rights violation through the federal government, and that allows them to come back after you. Now, I don't know, and I'm sure it probably has been done if, where somebody's been found guilty at the state level, and then they're tried again at the federal level. I don't know, this always comes up when somebody's found not guilty at the state level, then the feds come in and take you and they try you again.
But doesn't the state get first dibs because basically the feds are cheap and don't want to spend the money on it?
Not necessarily. I mean, that's usually the way it works. But like some of these police departments, or, I mean, if it's egregious enough, the feds will come in with their civil rights team and they'll charge people federally.
And then the state steps out of the way, right?
Right. State just gets out of the way.
So if they fail federally, can they be retried in the state?
No, double jeopardy. Now double jeopardy will apply. Oh, you mean if it goes backwards?
Right. Say the feds swoop in, they say we want it, and maybe they screw it up somehow, and they're not.
Yeah, I don't see why it wouldn't. It doesn't say it has to go up. It can go down. Yeah, as long as they both lay claim, have a stake in the crime.
So it's a lot like the OJ thing.
And it can happen. It happens every now and then with states, serial killers, different things like that. Where they can't prove they can prove that he killed so many people, but they can't prove exactly where it happened. But they know that it. I'm trying to think of a good example here, where each state could have a stake in that crime.
Didn't they federally charge Charles Manson?
Yeah, but you're talking about federally. I'm talking about two different states.
Well, that's what I'm thinking. Isn't that why they charged him federally? Because California was fighting with, I forget who.
No, wasn't Manson that was a state case, wasn't it?
Was it a state case? I thought he was in federal prison.
I
don't know.
He died in California.
Yeah.
Wasn't he in California? I don't know. I don't know the answer to that.
I don't either. I'm sorry.
Yeah, so that's it in a nutshell for Double Jeopardy. Questions, anything else on Double Jeopardy? I can try my best. Dave, you got anything?
No, good stuff, Jim. A lot of this stuff is things that regular people never get to hear.
All right. Well, yeah, because regular people don't get in trouble. So,
Well,
like I said, once you do get in trouble, now you get real interested in the Constitution real fast.
Hey, Jim, was Ted Bundy a federal case?
What's that?
Was Ted Bundy a federal case?
No,
I thought he was in different states.
He was in different states, but you know what? Maybe serial killer was a bad one, because typically what will happen is wherever they arrest him, that state will usually take charge, and they won't let him go until they finish their case. And then if he were to ever get out of prison, then he would have to go to Virginia to answer their charges.
Ted Bundy was arrested in Pensacola.
Right.
That's where they finally caught him.
Yep.
Didn't he kill most of his people in like Minnesota or Wisconsin or something?
I don't know. Tallahassee, right? I mean, I know he killed some there in Tallahassee.
Yeah, he murdered those girls.
He was in a few states.
Yeah.
Yeah, he was all over. But
it was multi-state, yeah.
Yeah, but he murdered some girls in a sorority in Tallahassee, and then he murdered a little girl from a city over on the peninsula somewhere, a little 11-year-old. And he was charged with that one.
All right, moving on. So the third part of this is self-incrimination. Nor shall be compelled in any criminal case to be a witness against himself. So in the movies where you're seeing people that are pleading the fifth, right? They're up on the stand, they plead the fifth. That's what this is. You cannot be compelled when you are, or a congressman, right? You see congressmen all the time. You cannot be compelled to give testimony which may incriminate you in the case at hand or future cases. You are not ever under requirement to give testimony against yourself, ever. And courts have ruled now that, gone as far to rule that the fact that you are remaining silent cannot be used against you by the jury. The fact that you do not want to testify, because it is a right. It's a covered constitutional right. The biggest case to ever come down, does anybody know what the biggest case for the Fifth Amendment to come down is? You all know.
I do
it.
not.
Yeah, you do.
Well, I might.
OJ.
Biggest Supreme Court case.
Miranda?
Miranda.
That is it, Miranda. So Miranda versus Arizona, 1966. You have the right to remain silent. You don't have to make any statements or answer any questions. You have the right to have an attorney with you present during questioning, and if you cannot afford an attorney, one can be provided to you. You have the right to, if you decide to start talking to me now, you have the right to stop at any time until you speak to an attorney. Everybody knows it. Everybody's seen it on TV. The courts ruled back in 66 that the police have to advise people of their constitutional rights when it comes to an attorney. And, bad cases make bad case law. That's all that was. That was people that were, cops that were abusing it. And there's good and bad with Miranda. Miranda's so ingrained in police work now and TV. And I think you would be really hard pressed to find anybody that doesn't know their Miranda rights. Everybody knows they have the right to remain silent. Everybody knows they have the right to have an attorney. There's been talk, there's always talk that it really handcuffs the police when the police are, because when we have somebody who wants to confess to something, right? There's nothing worse than having to stop when they are wanting to confess and tell them that they have a right to an attorney. And then, because what's the very next thing they do? Oh, well, I didn't think about that. And I'm not saying I want to trick people, but when we have somebody on the hook for, some heinous crime where, that we've talked to them and now they're going into a confession stage.
Is there a timeline that says you've got to do it like right now, as soon as you're going to arrest them? Or
Yeah, there is. So basically what it says is anytime that we have a custodial interrogation going on, you have to be advised of your Miranda. Now, you would think that custodial means under arrest, right? I mean, as soon as we put handcuffs on you, even if we're only handcuffing you to, for our safety while you're being detained, once the handcuffs are on you, the normal, reasonable person, you remember last week, we're talking about reasonableness. Reasonable person would believe when the police put handcuffs on you that you are under arrest at that point. Now, the courts have gone back and forth and they've looked at, we put you in the back of a car and if the door's open, not necessarily custodial, but if we close the door, reasonable person now does not have the right to leave. They can't just open the door and walk out. So at that point, if you're in a car and we're starting to question you, probably want to get Miranda in there. If you voluntarily, right, if you violate everything that we've talked about so far and you decide that you're going to go talk the cops out of charging you with this crime. So you voluntarily go to the police department and you walk into an interview room with them and you're talking to them and you confess to the whole thing.
You screwed yourself.
Admissible. Whole thing's admissible. You're voluntarily at the police department. You drove yourself there. You voluntarily walked in. Now we'll tell you, look, hey, I really appreciate you coming in. You know, you're free to go at any time.
Kathy's got her hand up.
As soon as we say that, done. Now, once you confess,
Kathy's got her hand up.
okay, once you confess though, then we immediately have to Mirandize you with any more questions. Once it becomes clear that you are going to be arrested for this crime. Kathy, what's up?
I don't know if this is addressed in any of the amendments, but going back to the piece about, not testifying against yourself. Where did the rule come in about the spouse not being required to testify against their spouse?
Yeah, I don't think that
I'm pretty sure that is, because once you're married legally, you're joined together as one.
where would it be? I mean, I don't think it is necessarily in there. I think the
It was
courts have probably
interpreted
ruled.
that way?
Yes, I think the courts have probably ruled. I don't know where that would be, and I don't remember ever reading that in the Constitution where it says anything about your spouse. Now,
Yeah, I don't think that's in there. I think it's just an extension.
I think that's one of those deals where the courts have made an exception to the Constitution,
Right.
that they're not required to give testimony against you. Same thing with doctors, right? Doctors aren't required, doctor-patient privilege. They're not required to give testimony against you. So yeah, there's exceptions to it, but I think those exceptions are, and that's what I was saying. I mean, we could talk all night about this. The whole purpose when we started this thing was just to get everybody to read the Constitution. And I think we were getting too far in depth. I would always, anytime that you think there's some kind of constitutional issue, be it personally with you're being arrested, be it something you're seeing on TV, right? You see Congress doing something. Hopefully now you're starting to get enough, dang, my other camera just came on. Which one am I on? Okay. Well, I got two cameras on now. I hope by now you're getting enough knowledge that you can at least say, hold on, man, something's wrong here, right?
Hey, Jim, sorry to interrupt, that other camera is the government hacking in and watching what you're doing.
Yeah, that's okay. That's all right.
Sweet.
I am 100%. Hey, I'll be a martyr.
If anybody
I'm
ever left on the Constitution, it's the government.
Actually, I say that, but I'm going to close that camera now. I'm a little nervous.
Not today,
So-
ISIS.
Yeah, not today. Not today, current administration. So yeah, there is so much case law to these things. So when something happens, you know where to go find it now. And I would hope that the first place you're coming is to research what the current case law is. And it's changing all the time. So things we talk about here, just for the sake of argument, I mean, Miranda, right now, I have to give your Miranda rights. Next year, might not have to. I mean, it changes that quick. And it changes with the different makeups of courts. And, look at the stuff that's going on with Roe v. Wade right now. Nobody thought that was ever going to change. And well, here we are. There's actually, in the post discussion tonight, I mean, there's actually a whole lot of court cases that are coming up and have been heard with this current Supreme Court that came out this week. There's some crazy times ahead of us.
Roe v. Wade next year, I believe,
Yeah. Yeah. Roe v.
End of
Wade's going
next
to be a
year.
big one.
or a year from now, I think it said.
Yep. That is, I just saw that today. So
There was just a huge win in the Supreme Court for gun rights.
Guns. Yep. Yes, there was. Yeah, we'll talk about that. It'd be a good post. All right. So self-incrimination, anything? Anybody else got anything? We're doing pretty good on time here.
Yep.
I'd
stuff.
comment, but I don't have anything to say because I don't want to incriminate myself.
Fair enough. Putting it into practice. Also, I want everybody to enjoy my beard. By next Tuesday, it will be gone because I have to work on Monday.
I think you turned off the wrong camera.
You covered up the camera, Jim. We can't see your
camera.
Oh, did I?
We
Yep.
can't see
Covered
your
up the good
fuzz.
camera, not the
Awesome.
government camera. There we go.
We thought you were kidding.
Wait a minute. So are you guys not seeing the Prezi?
We are
Yeah.
not.
Not seeing the Prezi, no.
Are you kidding me?
Nope.
Way to
No.
way to go, Jim.
I figured you turned it off because the update didn't work.
Yeah, that's what I thought too.
Haven't seen
We
it at
were-
all.
We were just admiring your beard and listening intently.
That's true. The beard is enough. I mean,
So what about now? Where am I at?
You're,
no, just you
we're still
Just
looking
my
at your
camera,
gorgeous
huh?
gray.
and that nice
Really?
flag behind you.
Really?
Yep. Yeah,
I
no
did-
Prezi.
Yeah, man, I did not.
I figured you
Danielle,
killed
I
it
see
when
you
he
too.
said the update didn't work. There we go.
There you go.
Now we
So
have
what-
it, but not you.
All right.
I got an answer on.
There you go. You
spouse.
got it.
Dang, man. Sorry. I had the slides up. I had
Got it.
everything. Had everything going the whole time. Yeah, I need you guys to tell me this stuff because I can't see Zoom when I have this up.
I thought when you said that you had an update failure, that you just shut it off.
No. All
You
right.
want to go back to the beginning and run through it real quick so we get to see all the slides?
I was reading them. I can.
Oh, okay. No, we're good.
If anybody needs them, if anybody wants them, you know what? When we get done with this, I should have time. I'll just go back. I'll do a real quick recap just so we have it for the video.
Yeah, there you go. Good
Um,
idea.
And then
Hey,
somebody had
Jim.
a question. Who just chimed in?
Daniela did.
Danielle has her hand up.
All right. Oh, sorry. Can you hear me okay through my Bluetooth?
Yeah.
Yeah, it's
Okay.
good.
So Kathy, your question about the spouses, it made me think of, I pulled out my old textbook of criminal law and procedure. It made me think of the conspiracy stipulation. So under English common law, conspiracy consists of an agreement of two or more persons to accomplish a criminal act, blah, blah, blah. We all know what that is. But the common law regarded a husband and wife as one person for most purposes. Therefore, a husband and wife could not be guilty of conspiring with each other. In recent years, the courts have recognized the separate identities of spouses, and there is no valid reason to continue the common law approach. Now, this goes on for a whole chapter, and I don't want to bore you, and I haven't had time to read it, but I do remember studying the whole spouse thing in criminal justice. I think that might be what you were asking about.
And where is that?
It falls under conspiracy
Okay, so it is. It's
offenses.
all right. Yeah, so I guess that answers that question too. I mean, I didn't remember, ever seeing it in the Constitution. But you got to remember too, when the Constitution was written, wives weren't given a whole lot of props in the Constitution. Right? It wasn't until later on that we started recognizing how valuable women were for society. So it doesn't surprise me that it's not in the Constitution. All right.
Thanks, Daniela.
All right, so moving on to due process. Now, due process is one of those things that we could spend an entire week on, 2 weeks on, but we're going to break this down real quick. And if you have more questions, you want to know more about case law and stuff, then I would encourage you to look it up. If it is something that we want to talk about, then let's talk about it. But as far as tonight goes, I'm just going to go through it real quick. So due process, nor be deprived of life, liberty, or property without due process of law. So the original meaning was that the federal government couldn't take your life, freedom, or property without following traditional legal procedures. That is not too far off what the current meaning is. So the current meaning, the modern definition through Merriam-Webster is one, a course of formal proceedings, such as legal proceedings, carried out regularly and in accordance with established rules and principles. Number two is a judicial requirement that enacted laws may not contain provisions that result in unfair, arbitrary, or unreasonable treatment of an individual. So in a nutshell, due process means that you have got to be afforded every process, legal process through the system. So you can't be found federally, they can't skip the grand jury, right? They can't just charge you with a crime and then find you guilty. We can't, if you want a trial by jury, you get a trial by jury. You have a constitutional right to a trial by jury. You have a right to a speedy trial. So if all of these have to be, every aspect of the process of law has to be followed.
May I make a comment?
Yep, for sure. I mean, that's what this is, right?
So the Supreme Court just ruled in this due process with regards to gun rights. There was a man and a woman who were married, and they were at home, and they got into an argument, and allegedly he pulled out an unloaded pistol and set it on the table and said, "Just shoot me now and get it over with." And that didn't come to anything, obviously. And then she left the house and called the cops and said, "Could you check on him, because I haven't been able to get a hold of him in a day?" And they came to the house, talked with him, said, you know, it was clear that he wasn't in any danger of committing suicide. But they detained him, and then while he was detained outside of his house, they performed an illegal search warrant and confiscated his guns.
It actually went worse than that.
Wow.
They talked him into going to the hospital
Yeah, right, into the
for a
psychiatric
mental
hospital for an
evaluation.
evaluation.
The only way he would go to the hospital is if the police promised him that they were not going to take his guns, and they did. As
Mhm.
soon as they went to the hospital, they went back, got permission from the wife to go into the house, and seized his guns.
Mhm. And then he couldn't get them back.
Right.
Like he
Correct.
petitioned them to get them back, and they refused to give them back, and it went to court, and then
And never been charged
ultimately
with a
down to
crime.
the Supreme Court. Never,
They
never
basically
charged with a
stole his
crime.
guns.
Right. And
Yep.
the Supreme Court said, absolutely not. You have to return his guns. It was not, due process was not followed for him.
And it wasn't just him. They actually ruled against the whole community caretaker
Mhm.
clause or act or whatever they're calling it. You know, where we show up for a welfare check and take your red flag laws is what it's going to
Yes.
come down to.
Yeah, the red
Yep.
flag laws.
They're going to
Yep.
find that red flag laws are
Huge.
completely unconstitutional because you're
Huge.
completely violating people's due process. Just because my neighbor says I'm crazy does not give the police the right to come in here and take all my guns, right? My neighbor says, I heard him say he was going to kill himself, or I heard him say he was going to kill me, but there's no evidence I did that. The police simply do not have the right to come in here and take all my guns. They don't.
Yeah,
Um,
and I've said it before in this group, but if we start allowing that to happen, we're letting liberal psychologists dictate gun law in the country.
Correct. Yeah.
The
100%.
APA is a 99% liberal organization.
Now, you go through the
Chamber.
whole process, and you get some doctor who swears that, yeah, you're crazy, and you're adjudicated to be crazy, or you're found guilty of, of some crime that's going to prohibit you from owning guns, and it falls within the letter of what the law is now, then okay. But you're not going to come in without following due process, without giving me my day in court, without giving me a chance to go in front of the judge and explain why this is all a bunch of garbage and I shouldn't lose my stuff and take my stuff. It's not going to do it.
Well, we already let scientists run the whole world, though. Why wouldn't psychologists too?
Yeah, anymore, right?
Well, and that's dangerous because a lot of people can be bought.
Oh, they're all.
And also using exes, they're interviewing exes, at least in Texas, because I listened to a podcast on the Second Amendment rights of Texas, and they started including interviews with exes on those red flags. And of course, an ex is going to say bad stuff about somebody and try to take away the right for them to carry.
Yep. Well, and you know what? It's and Brad can tell you, it's confirmation bias. Right? The cops decide that you're crazy, and anybody they talk to who gives them anything that remotely resembles you being crazy, and they're moving, man. They are going to move forward and come up and try to take your guns, and they're going to write it up that they had talked to you. And
Could you imagine if the APA was a conservative organization and we tried to say those with Trump derangement syndrome lost their First Amendment right to free speech?
Sure.
And their Second Amendment right to
and it's not
keep and bear arms.
Well, right, because we're all insurrectionists, right?
Yeah.
I mean, that's what they say. And it's not, you say, can you imagine? It is not too far off, man. I mean, we are not too far off George Orwell's Ministry of Truth.
We're not.
Where the Ministry of Truth, whatever they say, is the truth. And if you speak out against it, then you're going to be arrested. I mean, we're not, you would like to think that would never happen in this country, but there's a whole lot of stuff happening in this country right now that I would never thought would have happened. So, and like David
True.
said, I mean, this is why you guys, I mean, this is why we need to preach this. Everybody needs to know what their rights are and when their rights are being violated. And stop
Right.
taking it.
That's
Stop
right.
taking it. All right. And the last one is going to be eminent domain. Like I said, I'm not sure how this one ended up in here, but it is. So what eminent domain is nor shall private property be taken for public use without just compensation. Requires that just compensation be made if private property is taken for public use, like roads, like the Swinks just went through, the widening of Center Ridge. They came and they took part of their property and they had to give them just compensation. Just
National
compensation
parkland.
typically is fair market value. Now, it is important to remember that private property is not just tangible property. It can be ideas, it can be bank accounts, it can be anything. Anything the
saying-
government.
So you're saying intellectual property falls within private property that can be
Well, they're going to have to
taken?
show why they need it for the public use, right?
So if you
yeah.
came up and got a patent for some type of weapon,
Sure.
then they could
Or
say, we're going to take this because we need it for our military.
they could. I mean, if they could
Wouldn't that
prove-
have been what Apple used to fight when the FBI was trying to get into, I forget what it was, but like 5-6 years ago, there was some type of a crime that the FBI wanted to get into.
Yeah, that was out in, what was it, Arizona or some Western state. They wanted to get into his cell phone because he and his wife were allegedly.
They shot up a bank, or no, shot up a,
Yeah, he was an active shooter.
They were the ones
situation.
that shot up the Christmas party,
Christmas party,
where
yeah.
the people, where he worked.
Yeah,
Yep.
Oh, yeah.
and
No,
they
you're
tried
right.
to gain
Bernardino.
backdoor access. Yeah, San
San
Bernardino.
Bernardino,
that's it.
Yeah.
They tried to gain backdoor
I
access.
can tell you this, that from a law enforcement standpoint, if you own a phone, I mean, period, because everybody is secure in their stuff. It has nothing to do with you being a criminal. If you don't want the government involved in your life, Apple is pretty anti-government when it comes to search warrants, things like that. They will not open phones. Your phones, and we have no way to get into them. Apple iPhones are pretty secure, and they will
Well,
not.
the feds got into that phone. They got a private hacker to do it.
Right.
Yeah,
Well, trust me, but Apple learns.
Uh,
You're not
yeah.
getting that way again.
You know, I've worked in IT for quite some time, and I'll tell you what, there's very little that is impenetrable given time,
Oh, sure. I mean, everything has a back door. Everything.
and the government's no different. They can get into your stuff. So if you don't want your stuff found, keep it off your phone, plain and simple.
Keep it off social media.
Well, yeah, but keep it off your phone. Any picture that you save to your phone. Yeah.
So if the government says we want your piece of property because we want to make it part of the national park system, and you say absolutely no friggin' way, they're like, we're going to give you $1 million even though it's only worth $200,000, and you're like, no, I don't want to sell it. Are you obligated to give it to them with that $1 million because they want it?
Well, they can take it through eminent domain.
They would just end up giving you fair market value. Like you'd be better off taking the million. Otherwise, if they really want it, like if your property is 200,000 and they're offering you $1 million, you don't take it, they'll eminent domain you for the actual value of the property.
Right.
Well, they'll take it,
Mm.
but they'll,
I would
they'll
say
pay
But
you.
they also
sold,
have to prove, they do have to prove that they can't
Public
just
use,
randomly
right.
take your shit. They do have to prove that there's a true public use,
Right.
for it.
Well, this happened to a couple that was like in the Northfield area. I want to say like part of the national park system, probably like 30 plus years ago, that they're like, we don't want to move. We're not moving. And the government said, yeah, we're taking your property because you're the only one left on this road that isn't part of the park system. So like, we're taking it. Pretty sure they kicked them off the land and said, here's your money. Bye-bye.
Whatever happened with the court case? Did they take it?
I don't remember. I believe I believe there was a court case, but I think the Supreme Court said, or whoever the court said, you're out of luck. Sorry, it's
Well, there's,
eminent
and
domain.
there's quite a bit to eminent domain also. But again, we're just going over what the Constitution says. I was falling too far down rabbit holes for a while there. So real quick, let me go through this real quick, just so we have all the slides on the video. So talking about the Fifth Amendment, what it says. I'll just read it one more time. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken in public use without just compensation. Now, I will say this, that when we first read it, it was probably a lot, right? But after we explained everything, does it seem, when we go through it now, at least to me, after just reading it all, it seems like it makes a whole lot more sense now.
Right,
Um,
definitely.
When you
Absolutely.
understand what each section of it means. When we first read it, you're like, geez, what? Right? There's so much.
Mhm.
So it's kind of nice. I mean, that's why we break it down the way we do. 5 protections: indictment by grand jury, double jeopardy, self-incrimination, due process, eminent domain. If you remember the grand jury, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service or in time of war or public danger. Structure of that basically is closed, secretive sessions, no judge, no defense, no accused, no press. Rules for evidence basically non-existent. And it was originally designed to protect the accused. However, now it seems to work against the accused, my opinion. Exemptions to that are, except in cases arising in the land or naval forces, which is the active duty military, or in the militia when they are in actual service in time of war or public danger. Double jeopardy. No, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, which means the intent was to prevent the government from trying the accused over and over again for the same crime. Like anything else, there are exceptions. In this case, if the federal government has a legit claim to a crime that a state government also has, they can both try you for it. Like Rodney King, like Derek Chauvin, civil rights violations. Self-incrimination, nor shall be compelled in any criminal case to witness against himself. No subject is required to give testimony which may incriminate them in the case at hand or other future cases. Like we've always said, it's not your job to help the police make a case against you. Just shut up. Miranda versus Arizona, biggest court case for the Fifth Amendment. And I think we picked it up right after that. Everything else was probably on there.
That was hence the term, I plead the fifth.
Yeah, for sure. And look, man, I am the police. I want you talking to me, right? I mean, makes my job easier. But when I'm not the police, I mean, when it's just me and you talking now, when we're talking about just the Constitution and what your protections are, just shut up. Don't talk to the police. We're not there to help you when you've committed a crime.
Nothing you say can and will be used for you.
Yeah, exactly. Everything you say can and will be used against you in court. So that's it. Any questions? Any more comments on the Fifth?
Very informative.
Yeah, good stuff, Jim.
Good deal. We'll pick it up next week. We'll hit the Sixth Amendment. So now the Fifth, Sixth, Seventh, and Eighth all deal with court proceedings, be it criminal or civil. So these are all your protections as it applies to when you go to court. Things like we got speedy trial coming up. And then we've got civil trials coming up. You have a whole lot of protections, and we're going to go over them all in the next four amendments. But we will get done with the Sixth, maybe the Seventh. I'll prepare for both, unless you guys just want to do one a week. Anybody care? I mean, if we could fit two in, can we do two?
Sure, I'm working on my internet lawyer license.
All
I say
right,
knock
fair-
them out.
Yeah, fair enough. So you'll have a internet doctor and an internet lawyer. That'll be great.
Right.
Short and sweet, knock it out. Yep.
Just kidding. All right, very good. Then
Are
I
we
will
still
see you,
recording?
We are still recording. You want me to stop now?
no.
Yep.
Wow, we're leaving.
Okay. Stopping now.